Good evening, ladies and gentlemen, and a very warm welcome to this Current Legal Problems lecture. My name is Professor Paul Mitchell. I'm one of the editors of the Current Legal Problems series. My role this evening is to introduce the lecture chair. The Current Legal Problems lectures aspire to, among other things, foster dialogue between academia and the practicing legal profession. So we're particularly delighted this evening to have been able to invite Lord Briggs, a Justice of the Supreme Court, to chair the lecture. Lord Briggs has been a Justice of the Supreme Court since 2017, and of course, as a Justice of the Supreme Court, and prior to that, a Lord Justice of Appeal, he has an expertise that spans right across the whole of the law. But prior to his elevation to the senior judiciary, he had a practice in commercial and chancery law and practiced as a judge in the chancery division. So it's a particularly appropriate kind of pairing up, we hope, to have him chair this lecture by Professor Lusina Ho. So, Lord Briggs, perhaps I could hand over to you to introduce our speaker. Thank you.
Thank you, Paul. And thank you for the honour and delight of asking me to chair this lecture. I'm looking forward to it with eager anticipation, as I hope are all our viewers. We are privileged tonight to have with us, although in fact she's in Hong Kong, Professor Lusina Ho, who is the, and I want to pronounce it correctly if I can, Harold Xiaowo Li Professor in Trust and Equity at the Faculty of Law of the University of Hong Kong. Lusina is a prolific writer on trusts and equity, both English trust and equity, and indeed Chinese ones. And she has been consulted both by the government of the People's Republic of China and indeed by the administration in Hong Kong on matters, on trust matters, and has even been, I think it's fair to say, at the heart of the launch by the Hong Kong government of a trust service for special needs individuals in the territory. She's Oxford educated, and her knowledge and understanding of what we would rather parochially call English trust law is self-evidently from her writings of the highest quality. But I think you'll find that she is also a very original thinker about trust problems which have vexed us English lawyers for a very long time and which never really quite seem to go away. Tonight she's going to talk about the mental element in equitable accessory liability, what we tend to call dishonest assistance or knowing assistance in breach of trust. I would not be surprised if she encourages us to think about it in an altogether fresh and different way. So I'm going to pass over to Lusina. We're going to have questions and answers. Please, I think you've got a Q&A button which you can press to lodge questions and answers. So by all means do as soon in the process as you like. Don't do it all in the last 30 seconds if you don't mind. And then I will pick them out and put them to Lusina on behalf of those who have lodged them. So over to you, Lusina. Let's hear what you have to tell us.
Thank you very much, Lord Briggs, for the kind introduction. I'm also very grateful to UCL for having me. It's a privilege to be speaking to all of you this evening and to be able to do it from Hong Kong. I shall be sharing my PowerPoint slides on the screen. I think they're more fun to look at than my face. So here we go. Is it showing up?
Yes, it is. Yeah.
Great, thank you. So I'll just put on the slideshow. The topic of my talk is the mental element in equitable accessory liability. My thesis is that neither the current test of dishonesty nor the alternative test of knowledge is adequate to capture all cases in which an assistant should be held accountable. I propose to define the requisite mental element for such liability by reference to the defendant's intention and beliefs. The proposed change may appear radical at first sight, but I hope I shall convince you that it provides a better fit with the underlying rationale of accessory liability inequity than the idea of dishonesty, and thus is not as radical as it seems. If you don't mind me asking, I might have mistakenly sort of switched off from the slideshow. Shall I go back to it? There you go.
I think we have it.
Oh, you had it. Sorry about that. I couldn't see it very well from my end.
It sort of shrunk, but it's back to full size now.
Right, I see. Okay. Right, and here I go. My talk will be divided into three main parts. After a brief introduction to the current legal problem of the mental element for accessory liability inequity, I shall propose a theoretical justification for such liability, and then argue that the proposed theory sheds light on three doctrinal debates about accessory liability inequity. As you might expect, the last of these doctrinal implications is the articulation of a test of the mental element in terms of intention and belief. A natural starting point is the current test of dishonesty, which has a checkered history. It was laid down by Lord Nicholls in Royal Brunei Airlines in 10 and is to be measured objectively. The test is, in light of what the defendant knew, would an honest person consider what the defendant did to have been dishonest? As we all know, Lord Hoffman, aiding and abetting Lord Hutton, later held that properly interpreted, 10 requires defendants to have also known that their conduct was dishonest. Yet, 3 years later, in Barlow Close, Lord Hoffman retracted from that statement, saying that he had been misinterpreted by academics. It was not until recently that Lord Hughes in Ivey and Genting Casinos settled the debate in favour of the objective test in 10. Also, we had hope. However, a new debate has arisen, with Davis urging the courts to abandon the test of dishonesty and revert to the test of knowledge adopted before 10. He is countered by Rich and Dietrich, who defended the test of dishonesty for allowing a dynamic interplay between three core factors in determining accessory liability. The three factors are the nature of the primary wrong, the conduct element, and the mental element. What I propose this evening, in order to tackle the doctrinal debates, is to take a step back from the doctrinal debate to appreciate the theory behind accessory liability inequity. Unless we're clear about the foundation of such liability, we lack the tools necessary to tackle the doctrinal issues in practice. I also wish to say at the outset that I was encouraged, if not induced by Professor Charles Mitchell, to go down this path of inquiry, although I suspect that neither of us foresaw the conclusions I would ultimately draw from it. What theoretical basis am I proposing? I argue that the essence of equitable accessory liability is willing participation in a breach of trust or fiduciary duty. By willing participation, I mean that in assisting the breach, the assistants accept their causal role in bringing the breach to pass, and in that sense, endorse it. There are therefore two components of this theoretical justification: assistants' causal contribution to the primary breach and their endorsement of it. Let us now take a look at each of these in turn, starting with the minimum threshold of causal contribution required. In discussing the threshold causal requirement, I shall focus on those aspects of causation that are pertinent to the doctrinal debate on the mental element, and leave a fuller discussion of causation, including legal causation, for another day. As you can see on the slide, in accessory liability, a defendant's assistance produces a causal impact on the primary breach, which in turn produces a causal impact on the eventual harm suffered by the beneficiary. Focusing on the first part of this causal chain, to be sufficient, the assistance in question must be a factual cause of the primary wrong, but it need not be a necessary, let alone the sole or even sufficient cause of that wrong. These principles were recently reiterated by Justice Snowden in Bilter, albeit in loose terms, that is, that the assistance had some causal effect on the breach. I think there's definitely room to tighten the language and speak of the requirement of a cause in fact or a factual cause. Without this minimal level of causal contribution, a fully paralyzed person who renders no assistance but knows about and desires a wrongdoing could be held liable simply because of his or her evil thoughts. That can't be right. Turning to the second step in the causal chain, Justice Mance, as he then was, crucially held in Grupo Torres that it is not necessary for the assistance to be a cause of the eventual harm. Here, legal doctrine coincides with theory. Hart and Honoré have influentially argued in the context of tort law and criminal law that assistance causal contribution reaches only up to the breach, as whatever the voluntary primary wrongdoers do after obtaining the assistance is their responsibility alone. Thus, to hold assistance liable for a loss caused by the intervening trustee, it is critical to rely on their culpability, that is their mental state, to span the gap. As Justice Snowden explained in Bilter, proof of the mental element is, quote, the essence of the liability for dishonest assistance, unquote. This observation brings us to the other component in justifying accessory liability, that of endorsement. To determine when a person is sufficiently capable, we must first ask why he or she is treated as culpable. In this connection, it might be worth pointing out that a distinct feature of accessory liability, which is that liability may arise in relation to perfectly legitimate activities, such as the provision of banking or legal services. What changes the nature of such prima facie innocent activities is the culpability of the person engaging therein. If Boris Johnson shakes hands with an elderly woman believing that he has not got COVID-19 and having no reason to believe that he has got it, then he's being courteous. If he does so knowing that he has got the disease, then he deserves moral condemnation. So when is it culpable to assist a primary wrongdoer? In the sphere of criminal law, Sandy Kaddish draws on the notion of consent in agency law to argue that it is when the accomplice identifies with the actions of the principal offender. I think the idea of consent is very close to the mark, but there's a snag. In agency law, consent is concerned with conferring authority to perform an act, but this is not what culpable assistance does to the primary wrong. A more accurate idea is endorsement in the sense of accepting one's causal role in bringing the wrong to pass. Unlike the idea of consent, endorsement implies neither legitimation nor a position of authority on the part of the endorser. Endorsement encompasses a range of attitudes, from desiring a wrong to indifferently accepting it. Take desire first. People who desire a wrong are obviously culpable because their values prefer prejudicing a victim in order to pursue their own goals. Those who assist indifferently may be neutral with respect to such prejudice, but they still choose to bring about the harm in that they do not attach sufficient value to its avoidance to refrain from acting. In other words, they do not just sit back, they are willing harm causers and participants. Their endorsement is weaker than those who intend to bring about harm, but they nevertheless do endorse it in the sense of accepting their causal role in bringing it about. Just to hammer home the point, I'd like to borrow an example used by the philosopher Michael Bratman with respect to intention. For Bradman, intention requires a commitment to a plan of action to achieve a realizable purpose. Marathon runners who know that they will wear out their expensive shoes in a marathon may not intend to wear them out, but they still choose to do so. They are acting not for the reason of wearing out their shoes, but in spite of it. They still choose the unintended consequence as a matter of practical reasoning, and hence can be held liable for doing so. Once we accept endorsement as the theoretical basis of accessory liability, the key issue for accessory liability in equity is therefore to define a level of mental element that captures endorsement. In this connection, we can consider the three doctrinal implications of grounding accessory liability in endorsement. The first doctrinal issue is whether the mental element should involve a fixed standard or a fluid standard that varies according to the conduct of the assistant. Academic opinion is divided. Dietrich and Rich advocate for a variable mental element, whereby the more active the participation or contribution, the less one needs to know about the wrong to be held liable, and vice versa. By contrast, Lord Sales and Professor Paul Davies prefer a fixed threshold requirement. Intuitive as Dietrich and Rich's idea may seem, it is not self-evident. Some people may make more of a causal contribution than others due to a haphazard combination of events beyond their control. For example, when a bank processes a fund transfer for an errant trustee, the bank's assistance would be unnecessary, i.e. but for cause of the breach, if the other banks in the vicinity were closed, such that the breach would not have occurred without the bank's assistance. However, its assistance would not be a necessary cause if the other banks were open. In these scenarios, to lower the requisite mental element applicable to the bank that provides the higher degree of contribution would be to allow fortuitous circumstances to influence the imposition of accessory liability. I therefore agree with Paul and Lord Sales that a fixed threshold standard or requirement for the mental element is therefore preferable. The second doctrinal implication that arises from grounding accessory liability in endorsement is that neither the test of dishonesty nor that of knowledge fully captures the requisite mental element for endorsement. Let us consider dishonesty first. Since Ivey, the correct test has been as follows: knowing or believing what the defendant knew or believed, would an ordinary decent person have done what the defendant did? Much as one might hope for Supreme Court illumination on the standards of ordinary decent people, Lord Hughes considered dishonesty to be, quote, characterized more by recognition when encumbered than by definition, unquote. It is very tempting to criticize this test for being vague, but when it comes to setting a legal standard, vagueness may have merits. Even Professor Davies, the strongest critic of the test of dishonesty, champions a broad defense of acting honestly and reasonably because it provides flexibility to deal with a diverse range of fact variations. In my view, the weaknesses of the test of dishonesty lie elsewhere. First, it places the burden of proving all matters relevant to the assessment of dishonesty on the claimant. But some of these matters, such as whether the defendant was acting upon a good or compelling reason, are entirely within the defendant's knowledge. By contrast, very few people would disagree that a defendant who intentionally or knowingly assists a breach is prima facie wrongful. It would be fair to treat claimants to have proven so as having discharged their burden of proof and leave it open to the defendants to make out a defense. A cognitive-based test of prima facie liability, such as that of knowledge or intention, subject to a defense reasonableness, would rightly place the burden of proving these exonerating circumstances on the defendant. Second, and more fundamentally, the idea of dishonesty does not fully capture the notion of endorsement. Imagine this green light circle to include all situations in which there is endorsement. It is clear that dishonesty is represented by a smaller circle within the large one. This is because folk intuition, which Lord Hughes urged judges to apply, typically treats dishonesty as referring to deceit or deliberate concealment. And in most cases, dishonesty does overlap with deceit and endorsement. A recent example is the Court of Appeal decision in Group 7. In this case, the defendant, who was an accountant in a law firm, had vetted a client's proposed deposit while secretly negotiating a personal fee for assisting the client. He was clearly deceitful in keeping the firm in the dark about this deal. However, there are at least two groups of assistants who clearly endorse a breach, but do not do so in a deceitful manner. One example is people who openly and publicly assist a breach and must surely be held liable as accessory, even though they do not lie about their assistance. Another example, as I previously explained, is those who ignore a specific suspicion due to reckless indifference. They also endorse the breach, even though they're not deceitful. In turning a blind eye, in ignoring the suspicion, they are not turning a blind eye. They're not doing so in order to hide from the truth. They're just being indifferent. They couldn't care less. To label non-deceitful assistance as dishonest, the law would have to stretch the idea of dishonesty to include, as Lord Nicholls did in 10, called commercially unacceptable behavior, unquote. Yet this notion of commercially unacceptable behavior has been used in a different context and has proved notoriously difficult to determine in that context, which is that of disqualifying unfit company directors. And I thank Professor John Lowry for pointing this out to me. The better view is to recognize that because of this conceptual mismatch, dishonesty is not the most suitable apparatus for mapping endorsement. What about knowledge, subjective knowledge, that is actual or blind eye knowledge as preferred by Professor Davis? Let's sort out what these concepts mean before analyzing whether they are suitable for mapping endorsement. Of these concepts, actual and blind eye knowledge, only actual knowledge involves genuine, factive knowledge when one's belief is backed by reliable evidence and matches reality. By contrast, the term blind eye knowledge is but a legal shorthand for describing a level of ascribed fault. It involves not knowledge of, but beliefs about the breach. The actual mental state that is associated with blind eye knowledge is a suspicion of the breach. The label of blind eye knowledge is attached to assistants who deliberately disregard a clear suspicion for fear of discovering a truth that they cannot refute. There are therefore two components in this mental element. First, a clear suspicion of wrongdoing, and second, a conscious avoidance of the truth. What then constitutes a clear suspicion, the first component? The courts in Group 7, Payroller, and Bilter, these three recent post-Ivey decisions, have held that a vague feeling of unease or an untargeted suspicion is insufficient. In laying down this test, they drew upon the observation of Lord Scott in Manifest Shipping. However, the courts tend to leave unstated the requirement concerning the likelihood of assistance, believing that a breach will occur. I propose that to be held liable, assistants must believe that there is a real sensible possibility of a breach following their assistance. Now that we're clear what actual or blind eye knowledge means, we can consider whether it is suitable for capturing endorsement. And I argue that actual or blind eye knowledge is sufficient but not necessary for capturing endorsement. To illustrate, imagine this time that the green circle, this light green circle, also includes all cases of endorsement. I think it's fair to say that whenever there is actual or blind eye knowledge, there is this endorsement. Recall the father in Eves and Hickson who presented a forged marriage certificate to deceive the trustee into making distributions to his illegitimate children. Often, the absence of knowledge also indicates a lack of endorsement, such as in the case of the solicitor in Williams and Williams, who mistakenly assumed that there was no settlement, and when the said law reminded him otherwise, said it was all nonsense. However, knowledge is not necessary to establish endorsement. There are at least 2 instances in which an assistant endorses a breach without having actual or blind eye knowledge of it. First, consider again people who disregard a clear suspicion out of indifference. They have neither actual nor blind eye knowledge, but as I previously explained, they're willing harm causers who endorse the breach. Second, it is uncommon but conceivable that someone who intends to bring out a breach may not have actual or blind eye knowledge of it. A person who offers a bribe to a trustee with the aim of obtaining favorable treatment from the trustee clearly intends to bring out a breach, even though he or she may not believe in any real sensible possibility of the trustee's acceptance of the bribe. To intend an act, one only need to believe that its occurrence is not a fanciful possibility. It might be said that the courts could apply a lower requisite degree of belief to institutional instigators of a breach of trust. In saying that, however, we implicitly admit that intention is sufficient for reflecting endorsement. It might also be said that we should not be concerned with malevolence of such purity, as it is seldom established in litigation. This may be true of actual intention, but not recklessness, which is very, very common. More importantly, a test of intention and belief is vital for refocusing our attention on why acknowledgement is useful, namely to identify endorsement. Intention and belief are better tools for mapping endorsement because they're free from a reductionist focus on knowledge. Further, the prevailing approach in contract law and criminal law, and even across the shores in Germany, is to use the test of intention. In drawing support from these other areas of law, I'm not suggesting that we should apply a uniform test in all areas of law, in all areas of accessory liability, or to follow German law. There are unique policies in criminal law and contract law that are not shared in equity. For example, accessories of crime will go to prison, but not assistants of a breach of trust unless they also commit a crime in doing so. As to contract law, trust or fiduciary obligations have always been protected more rigorously than contractual obligations. I am therefore only proposing to adopt the same legal tools of intention and belief, which will facilitate comparison across these different areas without dictating a uniform threshold mental requirement in all of them. In the interest of time, but frankly also to induce you to read the full paper, I will not go into these laws in this talk. Instead, I would like to move on to the third and final doctrinal implication, which is to impose a test framed in terms of intention and belief. Such a test should comprise two threshold requirements pertaining to 1, assistant's degree of conviction or belief about the consequence of their assistance, and 2, the content of that conviction or belief. Degree of belief. At the highest level of culpability is direct intention and actual knowledge. Few would dispute that someone who in actual fact intentionally or knowingly assists a breach endorses it and should be held liable. Then comes oblique intention and blind eye knowledge. As I dealt with blind eye knowledge in the earlier part of the talk, I shall focus now on oblique intention, a label attached to those who believe who believe that a breach will almost certainly occur. It is only fitting in a lecture delivered at UCL to note that the label was coined by Jeremy Bentham. However, it must also be admitted that oblique and indirect intention have been severely criticized by Elizabeth Anscombe as dodgy terms. Appreciation of the underlying rationale of endorsement reveals that the misleading label of intention in this context is unnecessary. Someone who helps a trustee, believing that a breach will almost certainly follow, clearly chooses that breach and should be held liable for it. Let us turn to the next level of fault, advertent or subjective recklessness. By this term, I refer to situations wherein assistants believe in the real sensible possibility of a breach following their assistance, but nevertheless pursue it, press ahead and provide assistance because they do not care enough to desist. I have argued that such a mental state demonstrates endorsement of the breach. Crucially, as I show by parenthesis in the slide, there's a lot more in common between blind eye knowledge and advertent recklessness than their labels suggest. The actual subjective belief involved in both situations, as you can see from this slide, is the same, namely that the assistant has formed a clear suspicion about the wrongdoing. Their objective conduct is also the same, which is to render assistance to the primary wrongdoer. They differ only in their attitude towards the suspicion and reason for not making inquiries. The assistants in both situations should be held accountable. In pressing ahead with an advertence of such risk, the assistants willingly accept their role in bringing about the breach. The logical step to take to map the mental element exactly onto the moral justification of accessory liability is therefore to adopt advertent recklessness as the threshold mental element for accessory liability inequity. Doing so may lower the current threshold mental element for accessory liability. I say may because it is unclear whether current law excludes advertent recklessness as being insufficient for liability. On the one hand, post-Ivey decisions such as payroller, builder, have held that actual or blind eye knowledge is sufficient for dishonesty, but inadvertent negligence is not. Their silence on advertent recklessness, the level of fault between blind eye knowledge and negligence is palpable. It is also understandable given the association of the idea of dishonesty with deceitful conduct. Nevertheless, it highlights a major shortfall of dishonesty in that it leaves out clear cases of non-deceitful endorsement such as advertent recklessness. That's one side of the case law on one line. On the other hand, before 10, Category 3 knowledge of Baden-Delvaux concerning a willful, reckless failure to make inquiries was accepted as sufficient to be held liable for knowing assistance. In 10, Lord Nicholls considered recklessness to be a telltale sign of dishonesty, whereas more recently, in Clydesdale Bank and Workman, Lord Justice Lewison clarified that recklessness is evidence of dishonesty, but not dishonesty itself. Unfortunately, these statements are unhelpful because they use the term reckless indifference in a variety of senses. As Justice Nugent reminded us in Stanford International Bank and HSBC, a decision handed down in July this year, quote, reckless is one of the most unhelpful words, which means different things in different contexts, unquote. But crucially, in that case, in SIB and HSBC, Justice Nugent expressly affirmed the sufficiency of advertent recklessness for establishing dishonesty. What his lordship did was to adopt Lord Millett's discussion of the Baden scale of knowledge in Agib and Jackson. In Agib and Jackson, Lord Millett said that dishonesty is established where, in the first part, assistants suspect wrongdoing yet fail to make inquiries, and in the second part, the failure to do so is because they do not want to know, or, importantly, because they regard it as none of their business, and that is category 3, as Lord Millett recognized, category 3 of Baden knowledge. On the facts of the HSBC case, Justice Nugent held the HSBC did not have a targeted suspicion that the bank it was processing payments for was operating a Ponzi scheme, and hence it was unnecessary for his lordship to consider the second part of the dishonesty test as to whether HSBC was indifferent or turned a blind eye. Nonetheless, the conflicting judicial statements in the lower courts suggest that the issue is ripe for Supreme Court guidance. In my view, advertent recklessness should be adopted as the threshold mental requirement, and it would correctly draw the boundary of accessory liability in equity between inadvertent and advertent recklessness, rather than between advertent recklessness and turning a blind eye, as is currently the law. The distinction between avoiding the truth and not caring about it is very, very fine. Donald Trump recently demonstrated how fine the distinction might be when he took off the mask to give voters in October surprise. It is hard to tell whether he turned a blind eye to the risk of infecting others or simply did not care. But the point is, it should not matter. It should not matter because by rendering aid in spite of a clear suspicion of harm, thereby choosing or endorsing it, an assistant is sufficiently culpable. It does not matter whether the assistant was avoidant of the truth or could not care less. Instead, in my view, the morally and legally significant distinction for the purposes of accessory liability and equity should be that between advertent and inadvertent recklessness. Such a distinction allows us to confine liability to willing harm causes because only they act with a belief in the real sensible possibility of wrongdoing. The courts are also familiar with assessing evidence on the presence or absence of such a belief. AG of Zambia provides a graphic illustration of this point. In this case, Mr. Mir, who had been a personal solicitor of Nelson Mandela, allowed his firm's client account to be used as a conduit for the ex-president of Zambia to launder public money. Mr. Mir escaped accessory liability because he genuinely believed that there was nothing wrong with what he was doing and would have been horrified at the idea of being involved in laundering money for the president of Zambia. He defended his innocence by proving that he was, quote, a middle-aged naive person, unquote, who had been grossly negligent. Let us finally turn to the content of belief. The courts have so far focused on the assistant's degree of belief. They tend to leave unstated the requirements concerning the content of said belief, that is, what acts and in what degree of detail the assistants believe their assistance may bring about. Professor Davis has persuasively argued for the need to spell out the requisite content of belief, while judges have made it clear that defendants need not have known that they were assisting a breach of trust, that is, they need not have known about the legal significance of the relevant acts. The Court of Appeal in Group 7 did not take up Paul's proposal. It preferred to confine its remarks to the case at hand. It observed that in relation to the misapplication of trust funds in that narrow context, an assistant needs to suspect the primary wrongdoer's lack of entitlement to the funds. In my view, Professor Davis is right. A comprehensive statement of the mental element cannot afford to omit indicating the content of belief. The danger of that omission is darkly illustrated by the recent decision in Bilta. In that case, assistance was established when traders who purchased carbon credits provided the purchase money for, and hence made funds available to, the directors of the seller company to misappropriate. The traders were also held liable to have turned a blind eye to the fact that the credits were offered as part of a VAT fraud scheme. The court therefore found both assistance and dishonesty on the facts. What it missed, however, is that the traders assisted a breach of fiduciary duty, but were dishonest about a VAT fraud scheme. And it is not in the nature of such fraud that there would be a misapplication of funds by directors. Clarity in the law as to the content of belief would have avoided this blatant blunder. So how do we go about with the project of defining the content of belief? I believe two considerations are relevant. First, the less fine-grained the belief needs to be, the easier it is to satisfy the requisite degree of belief. The decision in Maxwell and DPP of Northern Ireland in the context of criminal law provides a neat illustration. And I thank my colleague Peter Chow, who's a criminal lawyer, a great one, for pointing this out to me. Maxwell, a member of a terrorist organization, had guided a car that took a number of people to an inn to carry out a bomb attack. He was held liable as an accessory because the court held that he needed only to have known the type or range of the offense to be committed. If he had needed to know the precise form of the planned attack, and that is the planting of a bomb, Maxwell would have been held liable only to have had foresight of the offense. Therefore, in setting the requisite level of specificity, the law needs to draw a balance between the interest of the victim and the freedom of the assistants to go about their activities. Second, the mental content requirement identifies the nature and scope of interest protected by accessory liability. Justice McLaughlin famously observed in Kenson Enterprise that the distinct interest protected in a fiduciary relationship is the fiduciary's undertaking to act in the best interests of the beneficiary. Bearing these 2 points in mind, it would be fair to define the requisite content of the belief as the core elements of a breach of fiduciary duty or a breach of trust, namely conduct that constitutes a conduct that constitutes a conflict of interest or a lack of authority to deal with the property in the manner concerned. Drawing together these strands of thought on the degree and content of the mental element, a test articulated in terms of intention and belief would be that to be held liable, an assistant must have one of these mental states. First, act in order to assist the trustee to perform acts that constitute the core elements of a breach of trust or fiduciary duty. Second, believe that the trustee will almost certainly perform acts so constituted. Or number 3, deliberately or recklessly disregard a specific belief in the real sensible possibility that the trustee will do so. This test may appear radical since it replaces the test of intention with one of intention or belief. However, recent judicial decisions on the test of dishonesty are groping towards the proposed test. I might just say again, at the risk of repeating, that, for example, Group 7, Builder, and Payroller have accepted deliberate disregard of suspected wrongdoing, that is turning a blind eye, as sufficient for dishonesty. It seems after Stanford International Bank and HSBC, after July this year, that advertent recklessness might also be sufficient. If this is so, what I'm proposing is not a radical departure from existing law, but an incremental step that provides a better fit between the law and its underlying rationale of endorsement. The only question is whether we stick with the label of dishonesty, being the devil we have known for so long. It seems to me that the choice is between getting rid of the devil, which the almighty Supreme Court could do, or accepting the lesser evil of interpreting dishonesty by reference to intention and beliefs, which is what the lower court seems to be doing. I think a test of intention and belief still has an edge, as it rightly allocates the burden of proving exonerating circumstances to the defendant, and it provides a better fit with the idea of dishonesty, which is often understood to involve deceit and deliberate concealment. I appreciate that after the quarter of a century that the courts have taken to resolve differences over the meaning of dishonesty, my proposal is akin to yet another round of COVID-19 outbreak. But one never knows. Perhaps it will prove itself to be a vaccine that immunizes us against future agonies. Thank you for listening. I very much look forward to your feedback.
Well, Lusina, thank you very much for that indeed. It was so full of careful thought and analysis, and I may say new thinking, that it's really difficult just off the top of one's head to come up with a question. One really wants to go away and think very hard about it for at least a week and then come back and ask questions. But we've had one brave soul. Oh no, we've got two now. Oh no, the second one is just a thank you. But we have a brave soul called Tim Pilkington who has asked a question, and I'm going to simply read it out for you. He said, could you please clarify whether your claim that endorsement is the underlying principle is either one, a claim that this is the principle that provides the best fit with the cases, or two, a claim about what the underlying principles should be? You can ask that an academic, but not a judge on the whole.
Thank you. That's a really, really good question. And thank you. You've given me a chance to set it out more clearly during the Q&A. I'm thinking of it really in terms of it being an underlying principle, an underlying justification, rather than the operative legal principle that judges will have to establish. And the reason I say this is really this. Endorsement itself really involves poking into one's minds and looking into the assistant's attitudes, you know, the inner realm of one's attitude, and that's really, really hard to prove. I mean, German law does that, and people are critical about it, but you know, maybe there's sufficient jurisprudence in German law for one to go about with it. As far as I know, English law is less concerned or less interested in looking into moral attitudes or reasons behind a certain decision. And that is why I think before one take the further step of using endorsement as the operative test or the operative principle, one needs to be a bit more careful. And hence at this stage, I'm thinking of it more as a principle, underlying principle, a rationale only.
Well, thank you. We can't ask Tim what he thought about that, but he may send me a chat note. However, I have another question. I don't have a name attached to it other than the curious expression BAC lecturer room 28, which may mean something to somebody, but not me, I'm afraid. The question is, should we try and reconcile the test for accessory, I think he means liability, with that of receipt?
Thank you. That should be lecture number 2. I have to admit I haven't really thought through it, but without giving it careful thinking. I mean, my thinking has always been that these two heads of liabilities are about different things. I mean, it's very interesting because in the past, in the early decisions, courts did not really draw a distinction between assistance and receipt. They really are just talking about participation in fraud. And in those days, I think they used fraud, in a broad sense. And for them, all that really mattered was that there was some fraud, and you're part of it. Hence, the idea of people being privy to the fraud. And so they did not really draw that distinction. The distinction is a more recent one, and I think it makes sense. One is about recipient liability, and the other is about accessory liability in the sense of secondary liability. And so on that basis, given that the extent of remedy in knowing receipt is sort of more or less confined to returning the value of the property that you have received, in a sense, sort of just giving up that receipt, or sort of being limited to that extent at the very least, as opposed to dishonest or knowing or intentional assistance, where the extent of liability is the full extent of loss suffered by the beneficiary and potentially much more extensive. I think it makes sense for accessory liability to hold a higher threshold than that of recipient liability. But that's just my current thinking. I'll think harder on it later.
Thank you. I wonder if a possible explanation is that of the historical original preference for receipt is that accessory liability is normally invoked because the pocket of the trustee isn't deep enough. And therefore one is looking either for the trust property to try and get it back and to fix upon a recipient an equitable obligation to return it where he claims to be entitled to keep it for himself. Whereas nowadays, of course, when the deep pocket may be that of a bank, in which case it doesn't matter at all whether they've received the property or not, that has caused a change in the focus of what this sort of accessory liability is all about.
Yes, indeed. It's very interesting because I remember Charles Harpham's seminal article on dishonest assistance that was sort of in the 80s. And at the time, Charles was saying that, well, we now have more cases of dishonest assistance, but some 40 years later, the number of cases have just shot up. And that's part and parcel of the range and breadth of situations in which dishonest assistance liability has been applied to. And that probably owes a bit to the fact that we've relaxed the requirement of fraudulent and dishonest design in the breach after Tanning.
Yeah, thank you. I've got some more questions. I haven't been running my tracker down the screen properly. We have from John Mee this question. He says, I've been really enjoying your lecture. Many thanks, Lusina. I was wondering about the boundaries of advertent recklessness. The phrase couldn't care less may cover only one aspect of that state of mind. What of a person who is not indifferent and who thinks that there is some possibility that a breach of trust may be taking place and upon asking questions cannot resolve the matter fully? If she decides that it's more probable than not that the transaction is honest, or that there's only a small chance that it's dishonest, is she liable?
Yeah, thank you, John. It's a really, really wonderful question and very insightful, as always, with his questions. My quick response is, actually, you're absolutely right. And as I was thinking through this, the levels of faults are actually in a continuum. And all we are doing at the moment, at least what I'm doing in this paper, is just to give sort of brief markers on certain salient categories. And there is a possibility of further fine-grained distinction. The question is whether and how far we go about with it. Because if we go too far down that line, then judges might say that's beyond practicality. It's not something we can really handle in practice. So that's why it seems to me that I agree with you, John, that you can make further distinctions, sort of depending on the range of attitudes, which can go beyond just not caring or turning a blind eye, and also on another sort of criterion, and that is the degree of possibility of the belief. I think if we do that, ideally, in the ideal world, we could, but in the practical world, maybe all we could do is just to accept a level of liability, sort of draw a line somewhere, and say that maybe if this line has been crossed, then that's sufficient suspicion for us to carry on. And I think that's, if I understand it correctly, that's the approach in criminal law as well. But one can think even further about these. I mean, German law, for example, would say that you can have advertent negligence and inadvertent recklessness, and you can have all sorts of combinations. But at the end of the day, I think we're going to have to sort of make a decision as to how far we draw these distinctions for the practicality of the law.
Yeah, thank you. I mean, as a merely practical judge, the ultimate question is how far beyond those who owed fiduciary duties at the outset is liability to be extended. That's what accessory liability means. And ultimately, it's partly a social question. It's partly, I think, a moral question. But ultimately, it's also a practical question, because the tools available to the courts and to those who provide the legal advice are necessarily limited, and they are those of the practical people in the real world rather than the psychiatrist.
Yeah.
And I think that's probably what lies behind your reference to practicality, and if it does, I completely agree with it. Now, we've got a very nice short question here, but it's short, but it's rather large, I suspect. It comes from Jian Guo, and the question is, would your theory, I think he means be, more applicable in the UK or Hong Kong or China?
Thank you. That's a really, really big question. I certainly was thinking of English law and probably common law. So that would work for Hong Kong as well. We are applying the common law. Chinese law on this, well, Chinese law follows civil law. So they would adopt the sort of German approach as well. Although I haven't looked at this aspect of Chinese law more closely, but they would put it in, the sort of general tort principles. And for them, common to civil law jurisdictions, they would adopt this German idea of dolus eventualis, and sorry, I don't know how to pronounce the other German label for the other level of fault, but their idea of intention is slightly broader than the English idea. So in a sense, there are similarities, but I think I wouldn't be able at this stage right now to be able to comment further on that.
I think that's fair. One more question from William Swadling, and I think our time means that this will probably have to be the last one. Lusina, a most enjoyable lecture. You said that liability for assistance extends to the losses of the beneficiaries themselves, not simply loss to the trust fund. Is there any authority for that proposition? And is it consistent with the notion that beneficiaries can't sue trustees for their own personal losses?
Thank you, Bill. You have the last word. Sorry, it might have been a slip of tongue when I was sort of answering the question on knowing receipt, on unconscionable receipt and dishonest assistance. I was thinking more of the loss of the trust fund as opposed to the beneficiary. So sorry if I've given you the wrong impression that I was making a point about separate extent of liability for beneficiaries as opposed to the trust fund.
Thank you. Well, I think I'm going to wind this up now by saying first to Lusina, enormous thanks for a really stimulating, fresh thinking, challenging lecture, which I think lawyers who have the good sense either to listen to this as it's being recorded or to read the paper will want to do a lot of thinking about as we go forward. It's a delight to be chairing an event which, thanks to the inventors of the broadband and Zoom, is taking place with a panel that's sitting right across the world between here and Hong Kong, and also, I think, participants and questioners in both those places as well. And that is, I have to say, a new experience for me, and one I have found deeply enriching, because it ensures that the community of legal practitioners and thinkers about these concepts of equity and trusts, which is worldwide, can really have our minds and our thoughts meeting across the globe to discuss and improve our understanding of them. Thank you to UCL for putting this wonderful event on, and to all who have participated and helped to arrange it in any way.
Thank you very much.